to toe the party line. Question 1. Question 2. Were the reasons that were given by Mr. Lamula rational, and were those the reasons that influenced the vote of the majority? Those are the 2 questions we need to answer. On the first question, which is there any admissible evidence of political party instruction or intimidation or threats? The EFF has produced no evidence whatsoever in support of threats, intimidation that resulted in this vote taking place in this particular way. They have referred to a statement that was published in the Sunday World, quoting Mr. Mantashe, where he states that the ANC has particular rules and that people should ask what happened to Ms. Makosi Khoza. But no evidence that this was ever communicated to members of parliament whatsoever. No evidence that he even went to the caucus, and if he went to the caucus, what he said at the caucus. So no connection has been drawn between the members of parliament who voted and the statement. And when you actually read the statement, it's actually useful to go through the statement. What you will find, and you will find that statement at page 146 to 147, you will actually find that it's not even a threat. What he says is that the NEC, which is the National Executive Committee, had given guidance. Those are his words, guidance. What you will also find is that that report also quotes other members of the ANC who say that they will vote contrary to a preferred party position. In fact, it says they were unfazed at the statements that he was making. So Minister Mantashe's statement does not come close to establishing an instruction or a threat. And then what was quoted today is a statement made by MP Mahambe Hlala, who tried to correct the record about how she voted and said, I want to vote in accordance with the party line. But there is again no explanation, no instruction, no evidence whatsoever about why she thought the party line is the correct line. What are the facts then? The facts are what the ANC has produced, and you have to admit those facts on Plascon Evans. These are contained at page 853 to 857 of the record. What we know is that there were 3 bodies that made the decisions. One is the National Working Committee. The second is the National Executive Committee. Both in the National Working Committee and in the National Executive Committee, the president recused himself. And then the third is the ANC Parliamentary Caucus, which consists of members of the ANC in Parliament. Secondly, we know that the NWC met on the 4th of December 2022, after the report had been published on the 30th of November 2022. And in that meeting, the resolution that was taken was that the report would be voted against because of an intention by the president to review it. No politics. It's a pragmatic decision based on prematurity. We also know that the ANC obtained advice from senior counsel on the 5th of December 2022. Senior counsel concluded that the conclusions in the Section 89 panel report could not be used in their current form. After that opinion was submitted, there was an NEC meeting of the 5th of December 2022. That NEC also concluded that the report would not be supported because of pending judicial review proceedings. Again, a legal reason, not a political reason. In the morning of the 13th of December 2022, we know that the ANC Parliamentary Caucus convened in order to discuss its own position. Now, there are two things that are crucial in that meeting. Firstly, as pleaded by the ANC, there were dissenters. There were some members who said that they would dissent from the position of the from the position of the NEC. And those dissenting voices were merely noted at that meeting. We also know from the statement made by Mr. Philip Modise, who refuted as false the allegations of threats. We also know another member of parliament, Mr. Qubudile Jantyi, who said that the decision of the ANC was based on the balance of evidence, and specifically said that the members of the ANC would vote according to their oath of office and constitutional obligations. And so what emerges then from this narrative that is at 8:53 to 8:57 is the following. The NEC and NWC debated the report in the absence of the president, who recused himself. Their decision to reject the report was based on prematurity, because it was at that stage subject to judicial review. Senior counsel advised the ANC that it would be premature to make use of the report in its current form. The Parliamentary Caucus considered the balance of evidence and noted the dissenting view of some of the members. So we ask you, Chief Justice and members of the court, to reject the allegations of threats as unfounded on the evidence. There were no threats, no unlawful acts of intimidation. Party discipline was indeed upheld, but personal conscience was respected, which is what this court requires. Then we must address the second question, which is, what is the substantive justification for the position taken by the ANC in particular? Now, we don't admit that one can come to court and challenge the ANC as such. It is only the National Assembly that can be challenged. But because much of the allegations in the founding affidavit relate to the ANC has decided to put the correct facts before the court. The position of the ANC is that it voted to reject the report in order to safeguard the impeachment procedure under the Constitution as such. It did so because it took the view that Parliament itself had to act lawfully. It could not merely rubber stamp the report of the Section 89 panel. And it is informed and inspired in that by the Nkandla judgment that I quoted at the beginning. That means that the National Assembly had the duty to satisfy itself of the lawfulness and the correctness of the report of the panel. What it did find was that the report was neither lawful nor correct. Why? Firstly, a debate has been held here about the distinction between sufficient evidence and prima facie evidence. But the consequences of this are much more severe than has been appreciated. We actually deal with them at paragraph 4.5 of our heads of argument. The panel is not a court of law, and so it's unhelpful to make references to standards in civil proceedings or in criminal proceedings. The panel is a tribunal, a subcommittee of Parliament, a committee established by Parliament. But this is why it's important. There are three stages that are crucial here. And at each stage, as Mr. Badland has suggested, there is a different evidentiary standard that must be met. At stage one, which is the charge sheet, actually the rule 129 capital A1A refers to the word charge sheet. The charge sheet must disclose a prima facie violation. If the charge sheet does not disclose a prima facie violation, the Speaker has no jurisdiction to refer the matter to the Assembly. To refer the matter to the independent panel, to constitute the panel. And then at the second stage, once the panel has done its work under 129G1B, sufficient evidence must then be established. And then the final stage, which is the stage of the impeachment committee, what they must do there is not to establish prima facie, not to establish sufficient evidence, but they must establish the veracity and the seriousness of the evidence, veracity and seriousness of the evidence. So, when one was listening to the debate, one could easily make examples from civil proceedings. A pleading must disclose an action so that it is not excipiable. So one could think about a charge sheet which must disclose a violation so that it is not excipiable. But the evidence itself is a different matter, which the rule 129G1B seeks to import. And so, if the panel came to the committee, came to the National Assembly without making a finding of sufficient evidence, it fails to make a finding of sufficient evidence. What it is doing is that it is not discharging its mandate. It is not doing what is referred to in paragraph 4.5 of our heads of argument. We refer to this as a jurisdictional requirement. The correct language is jurisdictional fact. So for the Speaker to establish a panel, the jurisdictional fact is a charge sheet that discloses a prima facie violation. But for the independent panel to be established by the Assembly, the jurisdictional fact that is required is sufficient evidence. This court is familiar with this distinction from the judgment of Corbett J. in South African Defense and Aid Fund versus Minister of Justice. It's a long paragraph, but in the last sentence, he says, if the jurisdictional fact does not exist, then the power may not be exercised, and any purported exercise of the power would be invalid. So if we are correct, and we submit that we are, that there was an obligation on the part of the panel to establish a jurisdictional fact of sufficient evidence, and it failed to make that positive finding, then the Assembly had no power to constitute an impeachment panel. And this is why we have characterized this as a jurisdictional error. But it did not stop there, Justices. It went beyond, because it also did not consider the question of evidence, confining itself to information. You are right, Justice Kolopin, that the panel must receive information, but it must process the information so that it casts aside what is not evidence, and then it leaves for the impeachment committee only evidence. So firstly, we have the wrong standard leading to a jurisdictional error, and secondly, we have the wrong standard leading to the failure to discharge a function that is assigned to the committee. This is why Minister Lamula, Mr. Badlander said Minister Lamula has been misquoted. He has been quoted correctly, but misinterpreted. The actual statement is at page 956A to 956F, where he outlines the problems. He says, this is not a mere terminological problem that I am concerned with. It's not a mere terminological problem. I am concerned because as soon as they failed to recognize that they had to collect evidence, they did basic things. If you look at 956C, they reversed the onus of proof and placed it on the president. They relied on inadmissible evidence and media reports. And they were found to have been wrong in at least one. They concluded that Mr. Hazim is probably a fictitious person. And a day later, Mr. Hazim, a day after the report was published, Mr. Hazim surfaced with a very basic inquiry by Sky News. And they were not saying that this must be referred to the public protector. What they were saying is that, and you'll see this at 956D to 956E, they were saying the evidence is incomplete, it is premature, and there are other institutions that have powers to investigate, and they may unearth additional information. And then, insofar as the PRECA issue, they said the problem there is that you did not make a finding of bad faith. It was interesting to listen to the ATM referring to bad faith, not in relation to PRECA, because Mr. Lamula was quite clear about where the bad faith issue arises. It is in relation to PRECA. But in addition to that, there is a dense critique of the report that shows simply how bad it was. And it is given in the President's answering affidavit at page 351, 352, and 353. I just want to make 3 observations from that, and they correlate with what Mr. Lamula was concerned about. They say, firstly, the panel sources, and you'll find this at paragraph 77, there were 2 statements from the police and their annexures. And then there was also a confidential report by the Namibian police pertaining to a Mr. Emanuela David. There were also audio clips of interviews with either suspects, one suspect, or suspects. But these were incomplete. Get a statement which is supposed to be 20 pages, but it is 11 pages. And the clips themselves were incomplete. So you get a portion, and you don't know what came before and what came after. And then you also get the sense that all of this came from a single source, Mr. Fraser. And you also get the sense that there was access to Namibian reports which are marked confidential, and you have no explanation whether these were stolen from the Namibian police or not, because the custodians of those reports were not before the court. And you have no sense when you get the statements what else was available in the context where those statements were pulled out of the Namibian police. So in these circumstances that the ANC said, let's put a bit of caution. Impeachment is serious business. If we are going to subject the head of state to this process, let us do at the very least 2 things. One, we need some comfort about the source, reliability, credibility of the information that we have in front of us. And 2, we also need to make sure that the panel has acted lawfully and constitutionally. Those are the fundamental justifications given in the answering affidavit. So you will see I've referred to Mr. Lamula's speech, and the court will take that into account. In summary, therefore, we say the ANC took the view that subjecting the president to a process of impeachment is a serious business. It is so because necessarily there is interference with the democratic choice of the voters. The voters have asked the man to run the country, but for weeks and perhaps months, he will now be cross-examined in an impeachment hearing. And at the outset, you must have jurisdiction to impeach. You cannot fix an alleged violation of the law by breaking the law yourself as parliament. And therefore, a president should not be subjected to an impeachment on a whim, nor should an impeachment be used as a fishing expedition. Thank you, Chief Justice.
Mr. Nukatobi, colleagues.
Mr. Nukatobi, Are you suggesting that the panel's report, despite the criticisms that may be legitimately leveled against it, would fall into either the category of a whim or a fishing expedition?
Yes, especially because the evidence is incomplete. And when Minister Lamula says, you are asking the president to hang himself because you've inverted the onus of proof. You said it's up to you to explain. That is a fishing expedition. And that is what he said in Parliament.
Could I just ask this, because I've been battling with this as well. The panel concluded that the president had a case to answer, correct?
Indeed.
The president takes issue with that because it says that's not the correct process to follow. That here's evidence and you, Mr. President, must rebut it. The president says the panel must look at the totality of all the information before it and come to the conclusion that indeed there is sufficient evidence of serious misconduct.
Yes.
And therefore it misdirected itself in terms of the process that it followed.
Yes.
So in that regard, are you saying that the question of whether the president had a case to answer is not the question?
That is an irrelevant question. It is part and parcel of the misdirections of law that were committed by the panel.
And then just finally, you heard the exchange between myself and Mr. Butlander with regard to the perhaps inherent and structural problems that the panel may have faced. Not all of the criticism could be ascribed to that. But is that something that this court should be concerned about, whatever its decision may be on the merits of this application?
Not in relation to the resolution. Because the structure of these rules, they make perfect sense, despite their attempts to undermine their structure. The panel is not to be restricted in what it can collect. It needs to collect information. But
it's restricted from who it can collect it, not so.
yes,
Only from members.
yes. Well, it got information in this case from Minister Zungula, MP Zungula, who had attached a lot of non-member information.
Sure.
Yes, so it did take that into account as
But
well.
then you run into the problems of hearsay, not so.
Yes, yes. Then it runs into problems because there's no limitation on the quality. It must be information, not evidence. So at the point at which it gets it, there is no requirement. But it goes through a process of sifting it and taking out what is not evidence and then leaving only what is evidence. What it cannot do, it cannot collect everything and then say, oh, well, here it is. When it does that, it's acting in error of its mandate.
Can I just test, and this relates really to charges 2 to 4. I won't try to distinguish between them too carefully. What point you say, and for what reason you say there is not sufficient evidence? Can we accept that General Roeder was in the Presidential Protection Unit?
Yes. No, let me just go back to Justice Rogers, to the actual report, because in fact I did want to deal with this.
Well, perhaps I can just ask my questions and then you can go back to the report.
Yes, yes.
If he was, could the panel also accept that it was no function of the Presidential Protection Unit to investigate the theft of money that Mr. Ramaphosa or his corporation may have suffered in its private capacity?
Well, let me go back to the report.
Sorry, it's a straightforward question.
Yes, yes, I am going to answer the question, but I do need to explain precisely the submission I'm making. So you go to page 137, well, 10 to 138. And you will find this everywhere, actually. 137, paragraph 238, and you will see there that the conclusion they reach is prima facie. You go to 138, 239, prima facie, and then you go to the charge 2, and you will find there the conclusion at 145, also prima facie.
But
So
prima facie evidence. In other words, evidence which, if it is not answered, may establish the charge.
Yes. Well, it says in paragraph 264 where the actual conclusion is that this information discloses prima facie. So it's prima facie information, not prima facie evidence. So
If
my,
all the panel can receive is information.
yes, but,
Can
Yes.
I ask you, I'm breaking away from my sequences of propositions, but
yes,
you question the information about Namibia. Would you say that that would amount to evidence if the whole transcript and the whole audio clip was there as opposed to only part of it?
well, there are two criticisms that were actually put by Minister Lamula. Number one is this criticism that unless you know the full chain, because you have, that's the one. The second one is distortion. In other words, it's information that is misleading. Even if it's evidence that is misleading.
Well, one
And-
doesn't know it's misleading. You say it may be misleading if you had everything else. All I'm saying is if you had a full transcript and a full audio clip as to part of it, as opposed to part of it, would you say that that would then be evidence?
Yes, if it was clear that it would meet some standard of admissibility, that's why they call it evidence. And no, it's not a court, it is a panel. But firstly, it must meet some threshold of admissibility. And secondly, it must not be cherry-picked. And those were the two criticisms.
Well, of course, we don't know it was cherry-picked. All we know is that perhaps it was what Mr. Fraser had.
Well, what we know is, if you can go to page 351 and 352, which is the analysis by the President of the information. (77.1, 77.2, 78, and 79. So you will see there that there is a problem about the incomplete nature. There is also a problem about the reliability.
But we must also take into account the, and it's been raised with you and your other colleagues by Justice Colopin and others, the panel is to some extent shoehorned into a process which must be finished within 30 days. It has no proactive powers to seek information. It simply evaluates information that has been given to it. But let's leave that to one side. I accept your proposition is that maybe the full transcript and audio clip would be evidence, but not just part of it. But anyway, if we can just continue. So,
Well, Justice Rogers, no, I don't say that they should have got the full transcript. I say that if the panel wants to make a recommendation that there is a prima facie, there is sufficient evidence, it can disregard information that suffers from these defects and then only take forward that information that it would be satisfied would constitute sufficient evidence.
or it may say, well, I've read what I've read in the transcript and I've heard what I've heard in the transcript. It may not be complete, but on what I have, it constitutes part of the evidence. But let me just carry on. So General Roeder was in the Presidential Protection Unit. It was no function of that unit to investigate the theft of President Ramaphosa's private money. And I assume you would accept it would be a serious abuse of power for the President to allow the PPU,
Sorry, Justice
as it
Rogers,
were,
I'm not waving at you. There is just a fly that is
Yes, no,
refusing, that is just refusing to,
I'm sure you're not trying to
refusing to
distract
disappear.
It would clearly be an abuse for a president to allow the presidential unit, protection unit, to, as it were, on the clock, use its, to go and investigate a private theft. I mean, there could be no doubt about that, surely.
If you did so mala fide, as required under the rules, and what also there could be no doubt about, whatever quibbles we may have as lawyers about the correctness or incorrectness of the Section 89 panel, the true question is members of parliament acting rationally with the information at their disposal.
Yes, now I just want to find out for what there was and wasn't evidence. The next thing is, it seems to me to be common cause that no case of theft was ever opened in respect of this amount, which totaled in rands about 8.7 million.
Well, what we know is that he says, the president, I'm not acting for him, he says that he reported it to his head of security.
Yes.
And
The head
it
of
was up to the head
presidential-
of security to open the case.
The head of a unit which is there to protect the security of the president, that has nothing to do with the loss of the president's personal money. That I think we must be, or at least the panel could assume that President Ramaphosa was aware of that distinction.
Well, I'm not sure I want to accept that he should be assumed to have been aware that if he reported it to his head of security, it will not end up with the police. I don't think that is a fair assumption.
Well, it was common cause several years after the event that there was no case opened.
Yes, that is true.
Just put yourself in the position of the panel, or you yourself. Perhaps 8.7 million rand is not so much money to council these days, but imagine, I'm sure I'm being facetious. Imagine you had lost 8.7 million rand.
Let me
Would you
not
be
respond. No, Justice Rogers, I mean, this is unfair, actually. I know that it's not, but it's really unfair in a matter of this public importance to make a joke like that and then to pass it on.
Let me then continue. 8.7 million rand, if, just as a matter of common sense, if a person loses 8.7 million rand, they would want to know who the investigating officer is and has it been reported to the police. Is there a case pending? And it's common cause that there wasn't.
Yes. But what is the question then for the issue that I'm dealing with in
Now,
my
I'm
address?
trying to
I see, we're getting
just
there.
see the totality of circumstances.
Yes.
Then we have, and the panel paid a lot of attention to this, the source of the foreign currency, because it did, in regard to charges 2 to 4, it was not merely the fact that there wasn't a report to the, under the Prevention of Corrupt Activities Act, it was, the finding of seriousness was that that was a deliberate decision because the president was wanting to keep secret the source of the money. That's the background to where the panel was coming from. Now, in that context, it seems to me it was the president's version, based on what Mr. Ndlovu told him, that an unknown person, who is then identified as Mr. Hamaz, comes to the farm on Christmas Day, just happened to be carrying in cash $580 million, $580,000.
Yes.
Yes.
Yes, and then?
And then he concludes the transaction not with the farm manager, not with the man who runs the buffaloes, Mr. von Willich. He strikes a deal to buy 20 buffalo from the lodge manager.
Yes.
And hands over $580,000 and gets this receipt that we've seen. And then the buffaloes stay on the farm and are never taken.
Yes, I'm still trying to work out where, in relation to the members of the National Assembly, the criticism is.
Well, if there was sufficient evidence of the various matters I'm putting to you, then one might say that the independent panel could legitimately come to the view that in relation to charges 2 to 4, there was sufficient evidence of serious misconduct, sufficient in context to be tested for veracity, not sufficient to convict, but sufficient to go to an impeachment committee. That's what their function is.
No, I submit no, because they did not actually make that finding. What would actually happen if we got where you are, Justice Rogers, is you would have to fundamentally rewrite the conclusions of the panel. That's why I was asking the court to have regard to page, there are actually several pages, 128, paragraph 204, 137, paragraph 238, 138, paragraph 239, 145, paragraph 264. It's so clear in those paragraphs that what they thought they were doing is to establish prima facie evidence based on information.
Well, we will read the whole report. You'll recall, I think, the acting Deputy Chief Justice put to, I think it might have been to Mr. Budlander, certain earlier paragraphs which appeared to indicate what the panel understood. But I accept, bear in mind, the panel here says, even after hearing the President's version, taking into account what he says, this is not just yet unanswered evidence. Together with his evidence, we take it that there is prima facie evidence. But if you say that that was the wrong test...
Yes. So, in fact, I think we are together. The criticism... if you want me to comment, let me know, Justice Rogers, if you don't want me to comment on the 2 paragraphs that Justice Madlanga referred to.
Perhaps let me just finish and then you can come back and comment on those 2 paragraphs. Yes. We then find that the $580,000 is not put into a safe, and I would have thought more importantly, it is not put into a bank where it would have earned interest at about 2,300 Rand per day. The first thing anybody who receives 8.7 million Rand wants to do is to make sure it goes into their money market account. You don't leave that much money, sorry, I'm now speaking as a matter of common sense. You don't just leave that money either in a safe or under a sofa. I'm not talking about, it's common cause that it wasn't banked and it was hidden in a sofa.
Yes. Well, the question is, what is the role of the members of parliament in relation to what the president knew at the time?
Well, if they read the whole report, because the structure of the report is before the committee starts dealing with the individual charges, which starts at paragraph 181,
yes,
where it starts with charge 1. It's had what seems, in the context of its report as a whole, to be a very important chapter 12 that runs from page 89 through to 173, including the conclusion in paragraph 171. And that's all to do with the source of the money. And it is clear from the panel at least believed on the information that had been submitted to it that it did not accept that the money had come from the sale of Buffalo.
Yes. Just
now, sorry.
Sorry.
And then, having considered the individual charges, it then in chapter 15 deals with the seriousness of the violation and the misconduct. And it is at that point that it ties in chapter 12 with charges 2, 3, and 4. To reach a conclusion, call it a prima facie conclusion, yes, that the reason why there wasn't a report to the DPCI and the reason why a case wasn't opened and the reason why General Roeder, as it were, off books, conducted an investigation and into the theft was because the source of the money was not legitimate. There was an attempt being made to conceal that was the case.
Yes.
Now, I assume you accept that if there was, let's just say, prima facie evidence of that, that would be prima facie evidence of extremely serious misconduct.
Yes, I have no difficulty accepting that at all.
And do you say that there was prima facie evidence of that, but not sufficient evidence?
Yes, no. Yes, I think this is where you and I, Justice Rogers, do not seem to be getting what I'm trying to say. I am saying the finding that must be made by the panel is sufficient evidence. If the panel erroneously fails to make that finding, that is sufficient to vitiate its report. And that is why I've taken the court to where the panel makes that finding. So my primary point is from the perspective of the MPs that were voting on the report, what they needed to look at, which is what was debated, did the panel act in accordance with its terms of reference? Its terms of reference required it to conclude sufficient evidence. Did they do that or not? They came to the conclusion that it didn't. And on that basis, they said we could not correct an illegality with another illegality. We would vote down the report. Now, it may be that one day, in a criminal case, the president will have a case to answer. It may be that one day, in a different case that comes before the National Assembly, the ANC will take a different position. But on this report, in these findings, the National Assembly was perfectly rational in arriving at the decision that it did.
Now, the expression prima facie evidence does still refer to evidence, but you say the fact that it is prima facie stands on a different footing from its being sufficient.
Indeed.
Now, in the context of the report as a whole, if one reads what the panel regarded as the evidence, and you say, but it formulated it as being merely prima facie, but if you look at that evidence and you say that although it called it prima facie, it was within the context of its function under Rule 129I sufficient, bearing in mind that it's not, as you have said, a veracity exercise. The context is it enough to go to an impeachment committee? What would you understand the precise difference to be between, let's assume for the moment it amounts to evidence. It amounts to prima facie evidence as opposed to sufficient. What do you say is the lower test which has been impermissibly slipped in?
The distinction is better explained by reference to the rules themselves. If you go to page 631, at Rule 129A, and 129A 1 sub A.
Sorry, 1?
129 capital A, brackets 1 small a.
Yes.
So the rule itself tells you that when the Speaker decides whether or not to constitute a Section 89 panel, she must already apply her mind to whether the charge sheet contains prima facie, what discloses a prima facie case against the President. But that changes fundamentally when you go to 633. Sorry, no, it should be
Where the
630.
sufficient evidence exists.
Yes, whether there's sufficient evidence that exists.
Yes, now,
Now-
sorry.
Yes. Now, what that means is that it is not up to the court, and it is not up to the assembly. It is up to the panel to come to the conclusion that sufficient evidence exists. That's number one. Number two, we know here, we don't speculate. We know precisely here that they did not intend to do what you are suggesting, Justice Rogers, because they specifically debated the difference, and they ultimately came to the conclusion that there is no difference.
There is no difference.
There is no difference. That is the conclusion.
Yes,
they
but
reached.
that was my question. What is actually the difference? Bear in mind what the Speaker does when she or he vets the motion is only looking at the evidence put up by the party moving the motion. That's the only evidence at that
Yes.
stage.
Yes.
That's one side.
Yes.
By the time it gets to the independent panel and it reaches its conclusion after it's gone through all the processes it must go through, it has also heard the President's version.
Well, we
And
can.
now the question is, in the light of all, and bear in mind, it is no longer the Speaker who is, as it were, doing a first cut, and the Speaker may, with due respect to her or him, not have any legal qualifications.
Yes. No,
That
we,
same evidence, plus any additional evidence that has now been placed before the committee, plus the President's response to it, all of that, is there sufficient evidence? Now, all of that has been considered. Now, in the context where you have not now only heard one side, but you've received additional information supporting the motion, and you've received additional motion against it from the President. Now you say, in the light of all of that, the formulated test is sufficient evidence. But what I want to know is, what is a lawyer conveying when they assess all of that evidence and they describe it as prima facie evidence rather than sufficient? What is the qualitative difference that you would then understand between those two formulations?
Well, the first thing we would know for sure is that they did not do what they were asked to do, which is to consider whether there is sufficient evidence. We know that as a fact, they specifically disregarded their terms of reference. And in fact, Justice Rogers, you're reminding me of something else. We found the actual terms of reference. They are in the SLA. We tried to submit them. There is an objection from the EFF. But it's important for the court to know the actual terms of reference that the panel had. If the court is interested, we would be happy to circulate those, but we've now got them. So we know for a fact that they disregarded their mandate. They were told they must find, positively find, not hide it in another language, positively find. And that is because, and this is important, that's why it's not a terminological problem. It's important because you are going to send this to lay persons, 400 of them, and you are going to ask of them to make a decision. And what they will have in front of them is they will have the terms of reference they gave you and your report. The first thing that will be glaring is that you disregarded what they asked you to do. And so when you are going to vote on it, about whether you need to proceed with this or not, the first thing that will strike you is that they disregarded the instruction that we gave to them. There is a different question, an analytical question among lawyers, which is, what is the legal distinction between the two? Now, the answer to that is that that distinction is foreshadowed by Parliament itself by making sure that the Speaker and the panel do not ask the same question. They ask different questions. And on the evidence, the question is, what did the parliamentarians understand the difference to be? What did the parliamentarians understand the difference to be? Now, on that, we have two sources. One, we have Minister Lamula's statement, which is 956A to 956F. What he says are the problems which distinguish information from the evidence. He says, number one, and you can, it's 956C. He says the first problem is the so-called conflation of information and evidence. And he explains that evidence and information in law are two different things. Information is knowledge obtained from investigation, study, or instruction. Evidence is what is legally submitted to a tribunal to ascertain the truth of a matter, and it must have passed the admissibility test. Furthermore, there is no analysis in the report which shows how the information which was provided to the panel was converted into evidence. He goes further.
Sorry, but if I can just pause there. At least Mr. Badnada understood to not embrace the notion that sufficient evidence has any connotation with what's presented in a form that's admissible judicially.
Well, we would submit that it must at least pass some standard. I mean, if, for instance, as I'm making the example of an incomplete statement, it's an incomplete statement. You have no idea what is the name of the witness. You have no idea where was it signed, where was it obtained. It is information, and it may contain crucial information.
See, I did a search of the phrase sufficient evidence in the statutes. It's used many times, and it's very frequently used completely unrelated to what might be admissible in a court of law. For example, in regard to BEE status and qualifications, has the person submitted sufficient evidence of this or that? There's even a reference to, is there sufficient evidence to make out a prima facie case? That also appears in the statute. An auditor must audit to establish sufficient evidence of something. You must submit a bank statement to the master or some other sufficient evidence. We're not talking necessarily about anything that's admissible in a court of law.
Yes.
So a document might be, even if it's not proved through the author of it, might be sufficient evidence or part of the evidence.
Yes, or it may be so unreliable that it should be disregarded because it would not even pass the threshold of evidence prior to its sufficiency. And this is what Minister Lamula said at the time in the meeting, because that is the true test, is what did they understand the difference to be, and can you impugn their understanding of that difference? So it goes further because it shows that there is a qualitative consequence. It was not just about text. Then he says, firstly, on the burden of proof. And it goes to your question, well, they had regard to the president's statement, but what did they make of it? The panel decided to evaluate which version is more probable instead of evaluating whether there is sufficient evidence for a committee to be constituted as per Section 89 of the Constitution. The panel effectively reversed the onus of proof and put the president in a position where he must disprove a version placed before the panel. Then it goes further, hearsay and media reports. The panel did not justify the use of hearsay evidence without the panel itself warning us about hearsay evidence. In paragraph 84, the panel tells us we are mindful of the dangers of relying on hearsay evidence and the caution to be applied in approaching such evidence. The panel failed to lay a proper basis for admitting hearsay evidence. The paradox played itself out in relation to information which related to Mustafa Hazim. It goes on and on and on. Remember, they said he doesn't exist. It turns out he, in fact, does exist.
So there's potentially incompleteness of some documents. There's a complaint about hearsay. Can I just ask you, what, in the context of this rule, what evidence do you say meets the test of sufficiency? Not in the facts of this case. How would you formulate a test that meets the standard of sufficient evidence? What is the level of sufficiency? Bearing in mind that it's not veracity, bearing in mind the limits on the panel's investigative powers, can't receive oral evidence, and bearing in mind that it's a precursor to, let us call it, a full-blown trial before an impeachment committee. So what is sufficient?
No, thank you, Justice Rogers. That is a helpful question. So firstly, we know what is outside. It's what would meet a prima facie, because that has already been done by, the Speaker.
I'm not yet clear of that, because I don't yet know. Maybe I haven't fully understood everything you've said to me, but I don't yet understand. Now let's talk as lawyers. I know the 400 MPs are not lawyers, but
Yes.
let's talk as lawyers.
Yes.
In the context of a panel that has heard the input, including the person against whom the charge is made, and then said, we believe this constitutes prima facie evidence of serious misconduct, instead of saying we regard this as sufficient evidence of serious misconduct to justify going to an impeachment
Yes.
committee. What do you understand the difference to be? So, and I think it would be helpful to address that question by first answering the point, what is sufficient?
Yes. Well, Justice Rogers, perhaps just give me 1 second to just follow the pattern I was following to answer you. I'll definitely come to that question. The first point, it goes to prima facie evidence. Now, the distinction I draw between the two, because that's the crucial distinction here in the context of the panel, is it's the sufficiency of the charge itself. In other words, if the allegations contained in the charge were to be established by evidence at a trial, would they constitute an impeachable offense? So that answers the first question, which is what the Speaker has to decide. Then it goes to the second phase. At the second phase, the evidence itself has not been tested
Are you
for
talking
veracity.
the second stage being at the panel stage?
No, I'm saying at the sufficient evidence stage, because there are 3 stages.
Yes. Yeah,
So stage 1 is the charge sheet stage.
Well, the motion, yes.
Yes. Stage 2 is the evidence stage, the sufficient evidence stage. And then stage 3 is the trial stage.
Where something presumably has to be proved at least on a balance
Precisely.
of probability.
Now, on the second phase, and we know this because, as you say, we must talk as lawyers, we know this because it happens a lot in civil trials. At the second stage, what the panel must be satisfied with is that the documents or the information it has would constitute evidence. Secondly, firstly, it must be evidence proper. In other words, it must not suffer from all of the problems that I've been alluding to. Incompleteness, clearly inadmissible, clearly misleading, cherry-picked, and all of those. That's the first question. The second question it must be satisfied with is the question of sufficiency. Now, on that issue of sufficiency, it must at least be satisfied that if this were to be put to a trial, if this were to be tested on a trial, it would be sufficient, there would be enough to take it to a trial, sufficient to to find the president guilty. So it's information we can take to a trial. So it's evidence that does not suffer from the defects I've spoken about, but it is evidence that would establish a breach of Section 89 of the Constitution. The third stage, which is the stage of veracity, is now testing the truthfulness of the evidence and not establishing its existence, factual existence, which is stage 2.
If the panel, independent panel, considers that there is evidence which, if nothing more is said, is sufficient to establish guilt, would that be sufficient evidence?
Well, it depends whether it is firstly evidence. If it is evidence,
Yeah, I'm now just step aside from this, but I'm trying to explore what the concepts mean. If a panel, talk abstractly, considers that there is sufficient, that there is evidence that if nothing more is said, if it is not disturbed, it will show serious misconduct, then is that sufficient evidence?
yes, it would be sufficient evidence.
Now, at least on my understanding of prima facie evidence, it means the same thing. Evidence which, if not answered, will establish the charge.
No, but not on these rules, Justice Rogers. Not on these rules.
Well, I'm not talking about the rules, I'm talking about the way a panel reasons. It reasons not on the strength of what it read in the ATM's original motion, which the Speaker looked at. It reasons with reference to all the information it had, which included additional information in support of the charges and responses from the President and some of his people against it. Now, on all of that, if by prima facie evidence, the panel is saying evidence which, if it is not disturbed, will establish the guilt, it seems to me that it's perhaps gone further than sufficient evidence. Because sufficient evidence means, is there enough to justify putting the President through
Yes.
this process? It doesn't seem to me that that necessarily entails evidence which, if nothing more is said, would actually result in a conviction.
Well,
So prima facie evidence, in the sense you and I perhaps understand it, which in the absence of an answer becomes enough evidence, that might actually be more evidence than sufficient evidence.
no, Justice Rogers, the only distinction I'm making, and I think it's important to keep that distinction because we are dealing with the rules. On the rules, the charge sheet must contain sufficient information on the charge that if there was evidence to substantiate it, there would be a finding of guilt. But the evidence itself, which is the second stage, is not the same thing as a prima facie. What they must then do is this evidence? And if the evidence were to be established at a trial, I suppose sometimes there might be a response, maybe there would be no response. If it is established at a trial, it would be enough to convict, to establish the offense. Beyond that, not just conviction, but seriousness to justify an impeachment. So it's not helpful, with the greatest of respect, to say in criminal law, this is how I understand the standard. In civil practice, this is how I understand the standard. What is helpful is to look at the rule.
Just finally, since you said, did I want you to comment on the passages that the acting Deputy Chief Justice put to Mr. Budlinder, a particular paragraph I would extract from paragraph 76, which is at page 90 of volume 1.
Yes, it is 75 and 76.
Yes, but in 76, the President shouldn't be required to undergo a full-scale impeachment inquiry where the President has no case to answer. That step may never be taken lightly. It is a momentous act justified only when sufficient evidence exists to show that the President has a case to answer for his conduct.
No, that's what I wanted to answer.
And do you say that that is itself a wrong statement?
Yes, exactly. This is itself a misdirection. That very statement is a misdirection. And the following statement is also a misdirection.
So if, including in the light of what the President himself and his witnesses have told the panel, and the assessment of all of that, the panel says, we have heard enough that we consider there to be sufficient evidence that there is a case to answer now in a veracity inquiry. You say that's the wrong inquiry.
Yes, well, this is not what they are required to ask, because look at the following sentence. The panel therefore functions as a filter to ensure that only a motion which establishes prima facie that the president has a case to answer is considered by the impeachment committee. That we say is the wrong standard. Even the earlier statement is the wrong standard because it is not a case whether the president has a case to answer. It is a case whether or not, as the rule states, whether or not there is sufficient evidence that there is a violation under Section 89 of the Constitution.
I would have thought, given that the panel has recognized the momentous nature of impeachment proceedings and the fact that its interposition between the motion and an impeachment committee is to ensure that that is not embarked upon lightly, that when the panel talks about insufficient, whether there is sufficient evidence that the president has a case to answer, it means sufficient evidence to justify the president being required to answer it in an impeachment committee. And I would have thought that that is exactly what sufficient evidence must mean. It doesn't mean sufficient evidence to convict. It doesn't mean it needs to have the same quality of admissibility that might be insisted upon by those who conduct the impeachment inquiry. It means sufficient evidence to expect the president of our country to answer it in an impeachment committee. Now, did you find that formulation objectionable?
Justice Majid said that he was not trying to argue a case against counsel earlier. But Justice Rogers, I think you've heard my submissions.
Well, I won't take offense to that if you don't take offense to my
yes. So, no, I've forgotten about that episode. So it's not going to happen again. But Justice Rogers, you've got my submissions on this. And I hear you. I won't say you're making submissions to me, but I hear the counter view.
Well, let me just put it to you, and this is my final proposition, and forgive me if you think I'm arguing, but I'm genuinely trying to understand what sufficient evidence means in the context of this rule and in the way that the panel used it, because that's central to the reasons why the majority of the MPs rejected it. And what I would want to know is whether, as a matter of law, in the context of these rules, does the panel act rightly or wrongly if it sets itself the test? Is there sufficient evidence to warrant the president having to face these charges in an impeachment committee? Is that an acceptable test?
No, the argument we make is that that is not what the panel did if one reads the report of the panel.
You say it's not what this panel said?
Yes, that this panel specifically found that its inquiry was about prima facie information.
But if we are to determine what is the difference between sufficient evidence and prima facie, if we are just to understand as a court what sufficient evidence means in the context of this rule, you would not quibble with the proposition that it means sufficient evidence to warrant putting the president through the momentous event of an impeachment committee hearing.
Yes, that I thought that is how I articulated the definition.
And your submission is that that's not
Yes.
the question that the panel asked itself.
Yes, they misconstrued their role because they didn't ask that question.
Thank you.
Okay, let me keep quiet.
Thank you very much.
I think Justice Matopo's.
Not that too fast. Mr. Ngugatobi, I've been following the debate between you and my brother Rogers. I want to take you to certain references in the report itself.
Yes, I need to just get. Yes, I'm listening, Justice Matopo. I just need to get the full report in front of me.
Well, just find it because I want to draw your attention to certain paragraphs in the report and go through them.
Yes, I've got it now.
Firstly, I kick off with paragraph 72. This is where the panel says, we have compared the terms of reference for this panel to those of the panel established for the removal of public protector. The powers and functions of those panels are substantially the same, save for one noticeable difference. The wording of the terms of reference The terms of reference for the removal of the public protector require the panel to conduct and finalize a preliminary assessment relating to the motion proposing a section 194 inquiry to determine whether there is prima facie evidence to underline it to show that the holder of a public office is guilty of any offense listed in section 174. And they say, by contrast, this panel is required to make a recommendation whether sufficient evidence exists to show that the president committed one of those grounds for the removal from the office.
Yes.
But when it goes further, it conflates this test. It talks about prima facie evidence. If you look at paragraph 75,
Yes.
that's where the prima facie evidence comes into the fore. Paragraph 75, paragraph 76, that follows. Now, one is left with a misapprehension as to exactly what test is the panel following and applying. Because clearly sufficient evidence, as far as I understand it, is not prima facie evidence. And in the context in which it has been used, the panel specifically made that distinction in paragraph 74 to say, we are now dealing with two distinct concepts.
Yes.
But when you read paragraph 75 and paragraph 72, there is a conflation.
Yes.
What are we to make of that?
Well, there are two ways of reading this report, maybe three if you listen to Justice Rogers. But I submit that there are two ways of reading the report. The first one is a fundamental misapprehension of the terms of reference. Right? It's told, go and find sufficient evidence. Then it decides it's not going to do that. It will do something different. And that's a misapprehension as to power, and therefore, on the jurisdictional facts standard, Panama is entitled to say, we're not going to follow an error of law. The second one is that there is a fundamental confusion in the analysis of the report, because firstly, it recognizes what it is required to do, and throughout the balance of the report, keeps conflating the two as opposed to separating them. On either of them, whether or not what I have tried to suggest to the court is illustrative of a misapprehension as to the correct legal test, or it is illustrative of deep-seated confusion. On either of those two, the Parliament was entitled to refuse to go along with it. The third possibility is what I've been discussing with Justice Rogers, if I understand him correctly, which is forget the nomenclature that is apparent in the report, do an analysis on your own. And what conclusion do you arrive at if you do your own analysis? Now, that is a very, very dangerous thing to do, because it is not your function to recast the report on behalf of the panel. It is not your function to place yourselves in the position of members of parliament. You have to accept the report as it is, accept the members of parliament as they are, not to rewrite it for them. I don't know how many other reports you'll do this for.
Is it correct that the panel's information, I use the word guardedly,
Yes.
information regarding the report, the compilation of the report, the information was scanty, or it did not have sufficient information? I'll read to you paragraph 80. Just look at paragraph 80 of the report. It says, we are concerned that we have not been given all the information that is presently available on the Phala issue. Just stop there.
Yes.
And this and it lists a various institutions that are investigating the case. In other words, they are saying we are hamstrung in our investigations. We are unable to come to a proper and justiciable finding because we don't have information. Is that
Yes.
assumption correct?
Yes, no, it is correct, and in fact, it's stronger, Justice Matopa, because it's precisely what Minister Lamula says. Remember that he was criticized by the ATM for taking into account this fact, because he also says, look, you have told us you don't have enough information to come to the conclusions, but nevertheless, you've come to the conclusions. And these inquiries, are pertinent. We now know with the benefit of hindsight. At the time that Mr. Lamula spoke, he only knew of one, which was this Mr. Hazim Mustafa that was said to not exist, in fact does exist. And then he said it's very, very dangerous to put the president through this on the basis of scanty information, because what that really does is that this becomes a fishing expedition. So it's correct that they themselves admitted that they did not have sufficient information.
In the bigger scheme of things, a panel confronted with a report or an investigation of that nature, I don't understand why they didn't ask for an extension.
Yes, in fact,
They make the point somewhere in the report that they are operating under serious time constraints. I will look for the reference.
yes, in fact, I think it's one of the criticisms by Minister Lamula, who says he doesn't understand. He
Well,
doesn't understand why they. Oh yes, it's at 956E. So if you look at 956E, 1, 2, 3, 4. 956E. So he says. 2, the panel could have requested an extension of the time period to finalize this report, which it only did once. The Zondo Commission requested extensions till we got tired. All right, anyway, the point is made.
Well, the last paragraph that I want to draw your attention to and ask for your comment is paragraph 82 of the same report. There they said, that said, we believe the truth of what really happened lies beneath the unanswered questions that are foreshadowed by what we are told from the information placed before us. We neither have the tools nor the power to excavate beneath the information that we have been provided with to uncover the answer to the unanswered questions. However, based on what we have been told by the information placed before us, the information that is either common cause or undisputed, as well as inherent probabilities, we are able to make our finding and provide reasons therefore, and make our recommendation.
Yes. It's illustrative of the bigger problem that although the panel claims to appreciate the momentous nature of the function before it, it didn't actually carry through that concern. Because if it claims, firstly, not to have enough information, and secondly, not to have the tools to get enough information, not to even ask for Parliament's assistance, because it would have been entitled to ask for Parliament's assistance, not to even ask for an extension, and then to simply say, no, we'll just make do with what we have. So that we would say is itself, as Minister Lamula pointed out, evidence of a misdirection.
Thank you, Chief Justice.
Thank you, Mr. Ngaitobi.
Thank you, Chief Justice. I'm indebted to the court and to Justice Rogers.
A reply, Mr. Premier.
Madam Chief Justice, members of the court, I don't have the graveyard shift. That's Mr. Katz's responsibility, but I'm going to try and make 6 simple propositions in reply in this matter, which should evidence why the relief sought by the EFF should be granted. The first one is this. The panel made a finding on the evidence presented in front of it, and the ultimate conclusion that it reached is that there is a case for the President to answer. Now, our learned friends for the respondents tied themselves up in knots in trying to rebut that, because every time, like in the debate between Mr. Mukaitobi and Mr. Justice Rogers, when the supposition was made, well, let's read, for example, sufficient evidence every time prima facie is used, would you object? And there was no cognizable answer to that, because what our learned friend Mr. Mukaitobi couldn't distinguish is what's the qualitative and what we would say is the substantive difference between sufficient evidence as relied upon in the rule and prima facie evidence as relied upon by the panel, but not as some free-flowing and free-floating concept, prima facie evidence as they understood to mean the same as the sufficient evidence which they discussed in paragraphs 75 and 76 of their report. And the panel knew, with all due respect, that they were subject to certain constraints. Shouldn't surprise you to know that, because when the panel does its job as the panel, it's acting as what we know in public law language as a creature of statute, or as a delegee that's constrained by the delegation of the superior power to it. And so the panel at various times acknowledges those limitations, and it acknowledges those defects in the rule which constrain its ability to perform its function. And every time it's aware of that, it uses language to tell you exactly the case. And Justice Matopo referred to paragraph 82 of the report. I would say look at paragraph 83 with all due respect at page 92. Because the panel says this: the President has rightly criticized the evidence contained in Mr. Fraser's statements as full of hearsay, in particular information from undisclosed sources. But on that specific point, the hearsay contained in Mr. Fraser's statement, they go on to conclude as follows: we are mindful of the dangers relying on hearsay and the caution to be applied in approaching such evidence. However, we are only concerned here with the preliminary inquiry and not the inquiry itself. So the panel gets dealt an imperfect hand, because in the course of the debate today, both the applicants, the EFF and the ATM, and some of the respondents have criticized the rule as containing anomalies or defects or whatever the case might be. But the panel doesn't have the ability to act outside that rule. And so when it does what it does, it reaches the conclusion it does, fully cognizant of those limitations on it, but nonetheless reaches the conclusion that there's a case to answer. So if you remove all of the semantic quibbling between the respondents and ourselves about whether there's an appreciable distinction between prima facie evidence and sufficient evidence in the way the panel applied it when they considered the evidence, not the same as when the speaker considered the motion, but when the panel itself considered the evidence, both for and against the contents of the motion, the unanswerable question is that there's a case to answer. That's proposition number one. Proposition number two is this. When the National Assembly came to reject that report, which says that there is a case to answer, they did not say that the panel did not find any of this evidence. They said it was a threshold dispute, and that the panel effectively committed an error of law in applying one threshold as against the other. But for all the reasons I addressed in opening, dealing with Magwakwa, and I'm not going there again, and having regard to the fact that the panel itself tells you how it reasons these two things, that demonstrates to you, with all due respect, that the National Assembly's decision that there is some difference doesn't even get out of the starting blocks, with all due respect. Because that reason, as we've submitted in written argument and in oral argument, is a distinction without a difference. What the National Assembly did is it latched onto some or other difference that it identified and elevated that to an error of law in circumstances where it is not that at all. And you know what we say about the difference in respect of those things and why they're not different at all. Proposition number three is that to the extent that the panel did, the National Assembly did disagree with the panel, and it did so on a political line of reasoning, which may or may not have been correct legally, but nonetheless emanated from political discussions, or whatever the case might be, we'd remind the court of what this court said in UDM 2017 Volume 5 SA 300 CC, and particularly paragraph 79. Members are required to swear or affirm faithfulness to the Republic. Nowhere does the supreme law provide for them to swear allegiance to their political parties, important players though they are in our constitutional scheme. Meaning, in the event of conflict between upholding constitutional values and party loyalty, their irrevocable undertaking to in effect serve the people and only do what is in their best interests must prevail. This is not only so because they were elected through their parties to represent the people, but also to enable the people to govern through them in terms of the Constitution. So we repeat that because we say there may be some world in which a political reason passes legal muster and a political party can rely on that to vote down a report. But we're saying that's not the case here. Because even if this distinction was engaged in bona fide by the ANC, it doesn't matter. Because when the reason is scrutinized as to why the report was voted down, there's no cognizable reason as to why that reason should be sustained. Insofar as proposition number 4 is concerned, and this is on the subject of delay, we would say that the question of delay has concerned the court significantly throughout today's proceedings. We would give 2 references, if we may. The first one is Notiyawa versus Makana Municipality and others, 2019 ZACC 43 at para 49. And what the court says there is that the delay and the extent of the illegality raised in respect of the impugned decision constitutes a weighty factor in favoring overlooking a delay, where, as in Gijima and Tasima 1, the illegality stems from a serious breach of the Constitution. A court may overlook the delay in order to uphold the Constitution, provided that the breach is clearly established on the facts before it. And we would say we're exactly in that territory here, having regard to what's happening. And the court went on to say there, this flows from the obligation imposed by section 172(1)(a) of the Constitution, which requires every competent court to declare invalid law or conduct that is inconsistent with the Constitution. We ask you to do no more. So to the extent that delay might stand in my way, it's, as I was debating with Justice Matopo earlier, it might be relevant as to remedy, but not as to the merits finding in the way that the court has understood it in Notiyawa. That's proposition number 4, 5, or 4, I think. Proposition number 5 is this. Is the debate that we're having here is one about the structure and the competency of the structure to vindicate the principles set down in EFF2. And the reference I gave earlier was to Glenister 2 at paragraph 234. It's actually paragraph 247. And what the court says there, and we say that that logic applies here as well, is that when they were discussing the powers of the investigating judge and the NDPP and determining policy, the court said this: the NDPP may on reasonable grounds refuse to accede to a request. This is a request of the investigating judge. That may place a considerable hurdle in the way of the retired judge's investigation. In short, an ex post facto review, rather than insisting on a structure that ab initio prevents interference, has, in our view, serious and obvious limitations. So insofar as our debate on the rule is concerned, we say that's what we're asking you to do, a la what the court did in Glenister. Make sure that the structure limits political interference. And I don't know whether that's time out or whether the court is going to ask me questions.
It means your protected time is over.
Okay, so I've got a last proposition then, subject to any questions being asked.
Make it
on the
very
court.
quickly.
Yes, thank you, Chief Justice. The last one is this, is that insofar as those reasons are concerned that were advanced by the National Assembly, what we know is that those reasons, well, the ANC as the controlling mind of the National Assembly constituting the majority at the time, what we know is that those reasons can qualify for unlawfulness both as a rationality challenge, that's the absence of the connection to the outcome, and reasonableness, because reasonableness was raised by, I think, our learned friend, Mr. Badland, or Mr. Ngukhaitobi, I speak subject to correction, that there's a distinction between the two. We say here that where the artificial distinction is as it is, there can be no reasonable outcome in the circumstances because of the reasons we've already addressed in Magwakwa and the other discussion we've had on evidence. May I take an instruction? I seem to be let off the hooks behind me. I don't know about in front of me.
In front of you as well, it seems.
Thank you, Chief Justice.
Mr. Katz?
Yes, this is truly the graveyard shift. And I'd like to make 4 points. The first is, if I understood Mr. Banda's response to Justice Rogers' question on the issue as to whether the administrative law type issues such as Westinghouse, etc., apply to a decision of the National Assembly, his response was, look at Scalabrini SCA 2013. If I understood his answer correctly as to rationality. I'm going to ask the court, when it considers that answer, to consider this court's decision 5 years later in Saripa, where this court, we would submit, qualified the Scalabrini test to say that arbitrariness occurs when there are no reasons. And when there are reasons, then one looks at how the reasons fit in with the notion of the purpose of the action. So Scalabrini, for the purposes of the debate with Justice Rogers and my learned friend, doesn't assist. It's proposition number 1. Proposition number 2, and the proposition number 2 is, even though when the National Assembly passes the resolution it does, in this case, it might not be PAJA, it might not be executive action, but there's no reason in principle why the Westinghouse idea doesn't apply to it. So if the National Assembly, or however one categorizes what it was doing, has 3 reasons why it does so, and one of them turns out to be rotten, it taints the whole decision. Like admin action, the same principle applies. The third proposition that I wish to make is I've listened to my learned friends on my right carefully, 4 hours, however long, and I didn't hear a word, not a peep, about the question of paragraphs 192 to paragraphs 194 of EFF2, and the question that there should be no political, well, this court said in EFF2, there should be no political interference in that gap between the complaint coming in, the charge coming in, to the impeachment committee. Not a word in answer. And there are 2 possibilities. Either my point is so bad that they don't have to deal with it, or it's so good that they can't deal with it. And I submit it to the latter. Just on that point, we're very attracted to Justice Colopin's questioning on the issue of 129I not being as clear as it could be and it should be. And I think Justice Duron picked up on that, and we would add that to our basket on the question as to why 129I should go together with 192, 194 of EFF2. The last point that I wish to make, the fourth point, is this. And here I'm not freestyling, I'm going to freeload from Justice Rogers' debate with my learned friend for the ANC, and it's a serious point. All of the respondents have spoken and presented argument as if the decision that the National Assembly was taking in December 2022 was the impeachment decision, and it wasn't. It was a decision, as Justice Rogers put to my learned friend for the ANC, a decision in that debate whether sufficient evidence exists not to impeach. That's a different test. Forget about prima facie, forget about all these issues. It was a question of sufficient evidence as to whether there should be a trial. And all of the kinds of arguments and the references to EFF2, all the paragraphs that you've heard of references, all related to that last question, to the last step in this big process of impeachment. We don't even get there in our case because of the 2 problems, the rule being bad and because of the resolution being bad. So we would submit that that which I'd argued before lunch and the kinds of relief that we speak of should be granted. As far as delay is concerned, this is not one of the 4 points. That's the kind of issue which, and I have no instructions, so my client is sitting behind and I can ask him, but it's the kind of point that perhaps, at worst, for my client, I can't speak for the EFF, it could be dealt with how you deal with costs. Some kind of balm against the notion of success. Let's say we win, we succeed in something or other, but you're disappointed with the delay. You might say something about that in how you do. You might. It's wholly within the court's discretion. Say whatever you want. So that's how we would articulate our replying oral submissions. Thank you, Chief Justice.
Mr. Katz, there's something I must correct. It's not that your argument was very bad or it was very good. It was you missed the argument.
Excuse me, I missed it.
You missed the argument about the political interference. Mr. Nukatobi took some time arguing that it wasn't political interference. His argument was that it was based on legal reasons. When he spoke about, let's just, I see you shaking your head, let's just talk about it. You say that those paragraphs 192 to 194 of EFF2 says there mustn't be political interference in those phases, right?
No, sorry, perhaps that was my third point. And
yes, I'm on the third point.
But the ANC only dealt with, if I understood it correctly, and correct me if I'm wrong, the question of the resolution. Didn't deal with the constitutionality of the rule.
Oh, I see.
So I only use
you're dealing with the constitutionality
I'm
of the
only
rule.
talking about 129 to 194 as far as the rule is concerned.
Okay.
So it's got nothing, I didn't hear a word about one.
Right. No, I misheard you. It's been a long day.
All right. Looks like we've reached the end of the long day. Thank you, Mr. Katz.
Thank you.
Court is indebted to all counsel for the submissions. Judgment is reserved. Court adjourns.